As it's quite a quiet day, the only news I've got is the 303s appeared in court today and their case has been continued. But we have had a motion drop in Chile's case against Google, etc. So it's plaintiff's motion for leave for surreply in opposition to YouTube, Google's motion to transfer or dismiss. Introduction. Plaintiff Jose de Castro respectively moves this court pursuant to the local rule for leave to file a surreply in further opposition to YouTube, Google LLC, motion to transfer or dismiss. In support of this motion, plaintiff submits a memorandum of law which is fully incorporated herein. If allowed, the reply would be no more than 5 pages and would be submitted by June 22, 2023, or within 7 days of the court's order, whichever is later. Most of the arguments in YouTube's reply require little response, as their defects are readily apparent. See reply, where YouTube puts evidence in the record showing the plaintiff has works registered after arguing that plaintiff doesn't. But at least 2 of defendant's arguments are worth addressing in a short reply. 1. Defendant YouTube tries to cure deficiencies in its motion. However, reply papers may only address issues raised in the move-in papers. It is improper to introduce new facts or a different legal argument in the reply brief, case reference with quotes. Since YouTube did not raise in its motions the argument that copyright registration was untimely, YouTube's argument for untimely copyright registration is itself untimely and should be disregarded. Even if YouTube is allowed to inappropriately raise the alleged untimely copyright registration of plaintiff's video, the video was actually registered prior to the second supplemental complaint in where it is mentioned, so their argument is irrelevant. YouTube doesn't support the legal basis of their untimely copyright registration argument anyway. Another case reference is an unpublished case that YouTube cites, wherein it was decided that where a copyright holder had filed a registration late, that the district court should not have dismissed the action with prejudice. Instead, it was decided that the action should have been dismissed without prejudice. Additionally, the copyright holder in another case reference could not cure the defect by amending the complaint. Here, plaintiff can cure any defect in failing to allege copyright registration by simply alleging registration in his second supplemental complaint. Additionally, another case reference ultimately relies on a district court case in the Second Circuit where the court admits to parting ways with several courts that have held that a post-registration amendment can cure the defect in a complaint filed before a copyright claim was registered within the meaning of and then references. Finally, YouTube's argument is moot. In general, courts have agreed that they lack the jurisdiction to make a ruling on a moot issue, but have done so only in the matter of public interest and other references. Brackets 2. Plaintiff never published a key video in its complaint. Chile's in it now. YouTube says that this fact contradicts plaintiff's FAC, but the key video in this complaint was not mentioned until plaintiff's request to make a second supplemental complaint, and is also mentioned in the second supplemental complaint itself. The video is obviously not mentioned at all in plaintiff's first amended complaint, even if it was published on YouTube. Even. I think there's one too many evens there. Which plaintiff denies. YouTube does not dispute that their terms of service only applies to products and services that YouTube provides to a user of YouTube's service. YouTube would have this court believe that allowing third-party users of YouTube to copy plaintiff's creative works is a product and service that YouTube provides to plaintiff, which is unconscionable. Allowing YouTube's users to copy plaintiff's works is not a service provided to plaintiff. YouTube continues to be oblivious to the fact that they were joined in this action because of their third-party liability to the infringing users of their service. YouTube is trying to abandon this action so that those users must take on YouTube's portion of the damages. It is possible that the YouTube user defendants in this action may need to make their third-party claims against YouTube under a forum selection clause between YouTube and those defendants. However, YouTube has not made that argument or provided evidence that those defendants agreed to the terms of service. Instead, they purposely mischaracterise plaintiff's complaint. Conclusion. Again, YouTube should at least be required to read the complaints in their entirety and plead relevant arguments, but so far its motion to dismiss lacks any merit. Plaintiff should be allowed to amend its complaint, but if plaintiff cannot amend its complaint, only the claims in plaintiff's first amended complaint, statute reference, will be lost. But the first and second supplemental claims would survive, as well as claims under statute reference, which don't require registration according to statute. Then the usual declarations. Well, that's a fun one. Thanks for watching.